Bill, who's approaching.
Your name, sir?
Joseph Fonzia.
Thank you. Okay, what are we doing?
Your Honor, I'm asking for an adjournment as I'm awaiting discovery. I was just pointed to this on Thursday.
During this matter, January 8th, 2026, 9 a.m. Bond continued. All right, thank you.
Your Honor, may I make a...
I'm sorry?
I was asking for to make a bond argument, but see.
Oh, okay, he needs to come back up then. Go ahead, briefly.
Your Honor, Mr. Fonville is in jail on retail fraud. From the written discovery that I have, there seems to be some confusion as to whether it was him or not, and I'm asking for a nominal bond, being that it was a non-assaultive offense.
People would object. The confusion around whether it's him or not was because he's allegedly using his brother's name while he was committing this string of retail frauds. There is an additional retail fraud charge that I am reviewing right now. In fact, I was just given the video for that moments ago that I'll be reviewing. It looks like him and another brother of his continually go in and out of different stores in the area and steal whatever they want. Mr. Fonville has an incredibly long criminal history with dozens of retail frauds dating back decades, in addition to long stints in prison for other theft crimes. He's held on a multitude, at least he was held on a multitude of cases. I don't have ex-jail up, so I can't make that representation accurately at this moment, but the people would object.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
We won't.
Where are they? Oh, he's coming out.
And good morning, Your Honor. Assistant Public Defender Ben Dunawith on behalf of Mr. Baldwin, who stands to my right.
Your name, sir?
Mr. Dion Baldwin.
All right. You're seeking a forensic evaluation? Or
Yes, Your Honor.
If I may.
Well, hold on a second. Actually, did you get a report?
No, I submitted the referral form to the clerk of the court by email yesterday. He's not yet been.
Order for an evaluation. Right, I see that. Okay, I'm sorry. Got it. All right.
If I may speak, Judge.
You wanted to say something? What do you want to say?
Yes, I wanted to relieve my public defender yesterday when he came to visit me. He just was incoherent with what I was saying. I wanted to proceed with a preliminary examination with 3 people to show for their side: Nicole Jones, Robert Jones, and Booker T. Jones.
What do you mean he was incoherent? You couldn't understand him?
Yeah, he didn't seem to be understanding what I was saying. He was asking me if I was the owner of the home. I was telling him no. I was applying for personal rep of the property.
So he was asking you whether or not you had ownership in the home on a home invasion case.
Yes.
What a shock.
My brother was the last to have ownership,
It's not really in your interest to discuss any facts of the case with the judge, whether you like me or not. It's not good for you to tell him the facts. It's best for you to be quiet, Mr. Baldwin.
So the 11/6 was the date.
So, sir,
of the last rep. Now
that involves a probate proceeding, right?
Yeah, so I have 63.
That's why your attorney was doing the proper thing, just based upon what you're saying, and asking regarding certain things regarding that. I don't need to know the terms of that, but that's just a natural kind of thing. And sometimes, if people don't really know what the probate issue is, it's hard to explain, which may have, and you probably were doing it improperly and not with the proper terms, which is probably why counsel may not have understood exactly what you were saying. It has nothing to do with him. So your motion to try to relieve the public defender's office, if that's your reason, is denied.
No problem.
And I will order the competency evaluation, and I'll set that for March 26, 2026, 9 a.m. Bond continued. Thank you.
Child support. He's currently being garnished the maximum amount allowable by law for 6 separate support orders. He's only getting garnished 6 separate support orders. He's
Okay.
getting about $200 for this particular one, which is ordered to pay $400, but only $200 from his monthly check are going to this order.
Every other week.
Every other week, it's putting him in arrears with many of the orders, but quite frankly, Your Honor, I would like to address bond because I think he just needs to get back to work.
Well, I don't know anything about that, but this is from a period alleged from November of 2020 to July of 2023.
And that is currently being deducted from his paycheck over at Trinity Health. But that portion
But is that current support being deducted?
with the
It's
6
current and arrears added to it.
separate,
Like they added my arrears and my current on that.
But what period?
So the period July to 2023, with the period you talking about, I wasn't working. I wasn't working at all. And like it was hard for me at that time. I was homeless. I wasn't.
Okay, I get all that, but what I'm saying is, I don't think that would be a reduction in bond. I mean,
well,
I think he owed like 20,000,
yes, Your Honor.
a little over.
And with the 6 support orders garnishing the maximum allowable under the law from his check every
I
week.
don't know, where is that like an exception? Because the garnishment, the maximum amount of his garnishment.
So I pay $900 a month.
Okay, wait.
Oh, I'm sorry, sir. I'm sorry.
Where is that exception?
Your Honor,
Why would that be an exception?
it is not an exception to his arrearage. However, the court rules only allow a certain amount of an individual's wages to be garnished.
Well, it's a statute that does that.
Statute, I apologize. However, with multiple children with support orders and arrearages, they will take the maximum that they possibly
Which I think
can
is 25%.
to,
So there's another 75%.
actually, Your Honor, under the friend of the court, they actually take more than 25%.
Okay, but there's still more left.
With 6 support orders, I believe they can take up to 60% of his pay, Your Honor.
Okay, that's fine.
Yes.
The problem is that he didn't pay for almost a 3-year period.
Yes, Your Honor.
So
And-
what is the bond argument?
Well, we don't have debtor's prison, and he's getting more and more in arrearage as he sits in jail, not paying the $900
It
a
isn't
month.
anything about debtor's prison. It's about taking care of your children.
Yes, Your
You got
Honor.
anything else in terms of a bond argument on this?
No, Your Honor.
All right, what do you want to do on this case?
Your Honor, we'd like to have a hearing.
You want a preliminary examination?
Yes, the state can bring in their accounting to see how they can take more money from the man.
It isn't the taking of the money, counsel, if that's what you're going for an exam for. It's his obligation that he hasn't paid.
Yes, Your Honor.
That's the criminal offense.
Yes, Your Honor.
Well, all right. You want an exam? We'll give you an exam. Would the people be able to have their witnesses available the 22nd? Or
Yes, Your
not
Honor.
the 22nd? When's my next day? The 13th? January 13th?
We can do our best, Your Honor. Thank you.
Right. Preliminary examination in person, January 13th, 2026, 9 a.m. That's before me. Bond will continue. So that the record is clear, move to modify his bond, which is already set at